And welcome back to Jeff Koinange Live. It's a full house today. Make that a full house of lawyers because of the situation we find ourselves in as a country. On the far end, Willis Otieno. In the middle, he's stepping in for Third Way Alliance presidential candidate Ekuru Aukot, who texted us a moment ago, or rather a few moments ago, saying he's in crisis meetings. Is Elias Mutuma. His mother calls him Elias. Everyone else calls him Elias. So we'll call him Elias. And of course, Kamoda Waiganjo right here next to me. Elias, karibu sana.
Asante sana.
Let me go to you first. Your candidate, Ekuru, had promised, he had confirmed he was coming, everything.
True.
Then he said he was in crisis meetings. What happened?
You remember that he has just been included as a candidate. A lot has happened since the Supreme Court rendered its determination. We've been having people, campaigning, appointing their agents, organizing their campaigns. He has not got that opportunity. So this is the night where, he has to go back to the drawing board to decide, which is the way forward. Where do we go from here? So those are the kind of crisis meetings that...
so we shouldn't feel so bad then?
No, you shouldn't feel so bad.
Yeah. Let me ask you this on his behalf.
Yes.
Is he going to withdraw?
I am not sure that he's going to withdraw. He said that there are issues that he needed addressed by IBC, and that's all that that means. It doesn't mean that he's going to withdraw. There was no point of us going through, the legal process, then we withdraw. It would not have made sense at all. But all he said is that there are issues that need to be addressed. NASA and Jubilee have been engaging IBC. He has not gotten that chance. So why can't he be given that chance, to also engage IBC?
Okay, real quick before we go around the bench. 2 weeks to the elections. Yes. Are you all ready? You're ready to engage? You're ready to do this?
That question should be asked to IBC. For us, we are ready. But
candidates are ready?
They are ready.
Your candidate is ready?
He is ready to engage.
And he's not withdrawing?
No, he's not.
All right, Willis, Form 24A or Letter 24A, that 24A?
Let me start by saying we have the Gazette notice of 5th September 2017, signed by Wafula Chebukati. Paragraph B of that Gazette notice is very clear. There shall be no nominations to be conducted. Now that Form 24A Chebukati is now referring to is a form that is prescribed as part of the regulations that are in the regulation, I think it's 51 of the election general regulations, which is applicable that upon the nomination of a candidate, if that candidate desires to withdraw, then you fill Form 24A. Now, in this cycle where we are right now, none other than Chebukati himself, in his own Gazette notice, has communicated that there is no nominations to take place. And I wish you could show to the people of Kenya on the screen that Gazette notice, paragraph B, no nominations. So if there are no nominations, and Chebukati proceeds to say it in his own Gazette, that we are conducting this fresh process on the strength of the decision of the Supreme Court of Kenya in petition number 5 of 2013, Raila Odinga versus IEBC and others, which said the candidates shall be the following. Ekuru has gone to court and has argued for himself. And the court, in its order, has admitted the IEBC to include Ekuru. The order issued by the High Court is in personam, directed at Ekuru. It is not in rem. IEBC, I'm now told, has issued a letter, a press statement saying, all the 8 candidates, including the one who had withdrawn, is now still a candidate.
So is the NASA candidate, let me come back to that, is NASA candidate Raila Odinga?
As at yesterday, 3:33 p.m. in the afternoon, Raila Odinga withdrew from this contest. And in so arriving at that decision, he was guided by the decision of the Supreme Court in petition number 5 of 2013. Even for argument's sake, at that time of withdrawal, those amendments in Parliament are not passed. That decision of the Supreme Court had not been explained to include Ekuru Court. So that was the law, and that is still the law that is guiding this process. So even including Ekuru was just out of abundance of caution. Nothing will have stopped IEBC, and nothing stopped them even now from starting the process afresh.
Does that mean, with IEBC telling us just this evening after the crisis meeting, that Raila Odinga is back on the ballot?
You know, Jeff, if you listen to lawyers and participants in a process, they will always give you their perspective. And, you know, I would be tempted to agree with Willis about the question of 424A. I think on that question, the commission may be on some untidy waters. But this is the reality. And I'll keep coming back to this point. As a country, we must continue determining whether we are a constitutional democracy or we are mobocracy, where whatever people say is what follows, and we put aside the constitution until it's convenient the next time. The commission is the one mandated to carry out elections. The commission is the one with the responsibility to ensure that elections are followed in accordance with the law. If the commission makes a determination, I don't think we as participants sit and say that's wrong, so we're not going to abide by those decisions. That is why the courts exist. And by the way, I'd rather we litigate until the last minute, because this is also about building institutions. If we don't build institutions, Jeff, we're going to need these institutions tomorrow. If Ekuru had not done what he said, and he said taken his supporters to demonstrate and stone the courts or whoever it is, how does that help us to grow as a democracy? Let us follow. IBC has made a determination. They may be wrong, they may be right. The opportunity is not to say we're not going to do it because we don't believe in what IBC has said. In a case, they're contradicting themselves. The reason why this constitution exists and sets up institutions is so that we ultimately subject ourselves to those institutions. Anything else, we might as well file away the law and let us see who's able to throw more stones, who's louder in TV studios. But ultimately, what will help us as a democracy is to recognize we're trying to grow a constitutional democracy. Is it going to be easy? Are institutions going to make mistakes? Of course. They are comprised of human beings. But the solution is not therefore to say, let's file away those institutions, let's weaken them. Let us continue to grow them, and let us go through the opportunities that are provided for in the same constitution. It cannot be that when I am uncomfortable as a participant in a process, that process cannot go on until I'm comfortable. Then why did we set up institutions? Suppose next time the other side is also not comfortable. Then where do we go? So what I am saying is, at the end of the day, there may be legitimate issues raised by NASA for all I know, but those issues have institutional processes through which they should be resolved.
Elias, I'll come to you in a moment. Let me go back to you, Willis. Do you think NASA candidate Raila Odinga, do you think he withdrew too early?
No. Let me say this. We've had a series of engagements with IEBC. In fact, Raila in person has appeared before IEBC no less than 2 times since the Supreme Court decision to discuss the electoral framework and the electoral structure of this country on the invitation of IEBC. Twice, one at anniversary, once at Bomas. Uhuru Kenyatta, who has been invited into some of those meetings, has never attended even one. So if it comes to a question of who is willing to engage, who has shown a desire to have a conversation on these issues, Raila Odinga has done that. Now, when he gave his irreducible minimums, and in fact, these irreducible minimums are fleshed out of the areas which the Supreme Court found to have been the cause of irregularities and illegalities. When we say we have a problem with Otimofo, for example, as I say it right now, here, there is an active Supreme Court order directing an access to the IEBC election servers. That order has not been obeyed until today. Otimofo has frustrated the access. In court, they say they are still asleep. We are 2 hours ahead of them. They can't give us those servers.
Although the CEO last week said that the servers had been opened.
Let me finish. If we start making allegations that are made on platforms, on political platforms, we're not going to help each other.
Let me finish. I was an advocate in that case.
Okay.
And I know for a fact, even in the judgment of the Supreme Court itself, the judges have said, their orders on access have not been complied with. As I sit right now, those orders have not been complied with. So we are simply saying, if the problem is that you have servers under the custody of a person who cannot facilitate the execution of a court order issued by the highest court in Kenya, then that person should not be part of our elections process. We have so many service providers across the world who will be willing to submit and respect the jurisdiction of our courts. We have said we have a problem, for example, with Al Ghurair. Why do we say we have a problem with that company? Very simple. This is the company that printed the forms that were used to declare results. The Supreme Court of Kenya did find that no less than 80 of those forms were fake. Until today, Al Ghurair has never come out to say that those alleged fake forms did not come from us. That as we gave out, these were the actual forms and they were genuine. Now, if you have a partner who cannot even own up when its own processes have been impeached by the highest court in the land, in our view, respectfully so, that is a partner that should not be part of our elections process.
Answer my question that I asked before. Is Raila going to come back? Is he going to put himself back in the race?
To the extent that yesterday at 3:33 p.m. in the afternoon, Raila Odinga, in recognition of the decision of the Supreme Court, abandoned his electoral quest, there is no other way he can be brought back to this process unless fresh nominations are held in accordance with that particular decision.
Okay, now three things.
Before I go to you, 1 second, one real quick.
Yeah.
Elias,
Yes.
I have to bring you in here and ask you real quick. Does the Kurwa Court have any irreducible minimums of his own?
Well, what he said, and what I know is that he said there are issues that need to be addressed. They are not minimums, they are not irreducible minimums, but they're just issues that need to be addressed. And like I said, we have seen NASA engage IBC, we have seen Jubilee engage IBC. If it has to be, a level playing ground, let him be given that chance. Let him know what has been going on between NASA and IBC and Jubilee. That's all he needs. I mean, to have that platform, to speak his mind and to hear what IBC has done in terms of the reform, so that he knows that the way is clear or it's not clear.
Does he know that he only has 2 weeks from tomorrow?
Yes, and he has not been sleeping. We knew that we would win this petition.
You knew?
Yes, we knew. I mean, it was clear. You would ask a layman what nullification of an election means, and they would tell you, if the court nullifies an election, it means we didn't have an election. So we do not expect that the High Court would have ruled in any other way.
Yeah.
So we also been working behind the doors.
The fact that the High Court put the other candidates to piggyback on your candidate, I mean, allowing all of them.
Yes.
You think that's fair?
Well,
No, the High Court did not. Let me just correct clarification.
No,
the High Court
let me
did
answer
not.
that,
The High Court did not give an order allowing all the others. The orders are specific to them. They are in personam. The High Court only discussed the others.
Oh.
There are 2 orders that were given by Justice Mativo.
Yes.
2 only. One is a declaration, because it was a constitutional petition on violation of rights, specific rights in respect to a specific person.
Yes.
The first order that was given by Justice Mativo was that he finds that IBC violated the rights of Dr. Ikuru Aukot by failing to include him in the ballot. The second order was, consequently, he ordered IBC to include the name of Dr. Ikuru Aukot as a presidential candidate under that Alliance party ticket. That is the order of the High Court. That was it.
Okay.
Let me say three things.
Yeah.
Because I think part of the problem with the conversation in this country is that there's a lot of dishonesty in these conversations. You see, we give half the story. Like, for example, the point that my 2 good learned friends have given is true to that extent. But what they fail to say is that the court, in making that determination, itself said that it would be wrongful for anyone to be excluded. In fact, they defined what a fresh election means. It means its foundation was in the previous election, and so therefore everyone who participated is entitled as a matter of right to participate in the election. But because those other people were not parties to this case, of course it could not give orders in the specific situation, but it did contemplate that each of these parties actually entitled, and that is what the IBC is following. Because what you don't want is tomorrow, if they exclude whatever the others, they then go to court and say include me also. So the most prudent thing for the court to do is to allow the others. So what I am saying is that it's important in this process to also educate Kenyans, even if the position that we are advancing is not necessarily helpful to our cause, because this is not just about a competition for whose view is better. It's also about educating Kenyans so that they understand what is going on. The other point to say is this: the reality is that the determination by the court today resolved some issues. The truth of the matter is that after the withdrawal yesterday by Honorable Raila Odinga, there are very many issues that were left hanging. Today, the court resolved some of those issues, including defining what what an election means, a fresh election means. It also said that in a fresh election, you cannot have nominations. The things that Willis Otieno he said, you cannot have nominations. Why? Yeah. Because if you have nominations, that it will mean you'd have to violate the 60-day provision. So what I'm saying is, because we have institutions, when institutions make determinations, surely the least we can do, those of us who preach that we believe in the Constitution, is to abide by those decisions. If we decide this is not convenient, this one is convenient, it is not right for Kenyans. And for us, especially as lawyers, it's important that even if a position conflicts with what we believe in politically, that we at least try and help tell Kenyans that this is still the position, even if I don't agree with it.
Yeah. Let me say this. Let me just mention this. I am a student of law, and I read the decisions of the Supreme Court. I try to keep abreast with all of them as and when they come. And one of the decisions which I have spent the last 4 or 5 years reading keenly, almost word for word, is the decision in petition number 5 of 2013. Because that was the first landmark decision of the Supreme Court of Kenya after it was put into place. And at paragraph 290 of its decision, that court says this: suppose, however, that the candidate or a candidate who took part in the original election dies or abandons the electoral quest before the scheduled date. Uhuru Kenyatta, Raila Odinga, or the others, dies or abandons, God forbid dies, abandons the electoral quest before the scheduled date. Scheduled date is 26th of October. Then the provisions of Article 138, I think that was revised to 138(5)(b), will become applicable with fresh nominations ensuing. With fresh nominations ensuing. That is a decision of the Supreme Court. I've heard some people argue that decision is obiter. But you must ask yourself, what is the legal effect of what, even if I agree that it's an obiter decision of a Supreme Court, what is the legal effect of an obiter decision of a Supreme Court? You know, let me just finish. This is a very important point. Yeah. The Supreme Court of Kenya has been invited to answer that question. Yeah. In the case of Ken Aramat versus IEBC, that was an election petition, where it said when a Supreme Court renders itself, it applies its mind on any issue, such that what may even be an obiter of a Supreme Court is of binding force. That is the Supreme Court of Kenya who said it, not me, in Aramat's case. Right. I was not even a party in that particular case. So that what I'm saying is this: faithfully reading a decision of the Supreme Court, and I do believe, I may be wrong, but I think I'm very right, the Supreme Court is the highest court in the land. It has addressed itself to some of these issues. And that is why I said the case of Ekuru, he was litigating on violation of his rights. And the court found that there are violations of his rights and gave him an order which was specific to him. So that, for example, let me ask you, Cyrus Jirongo, from what we've read in the newspaper, media reports, he's been declared bankrupt. Right. If the information is true. Can IBC, does he qualify to be a candidate in any election in this country? He doesn't. And that is why the court was dealing with the issue of the petitioner who was before it, Ekuru Court. If another commissioner, another candidate wants, they must go through the process. They can use Ekuru's case as a test case for them to be formally admitted into this process.
Okay. Bearing in mind that there is a 60-day window.
Yes.
October 31st is probably the last day. Yes. November 1.
Yes.
We'll have no government, so to speak.
That's not true. Far from it. Let me say this. 60-day window that we had, that 60 days is enough to conduct nominations. Because you are guided by Section 14 of the Elections Act, 21 days notice for the holding of an election. You can do all that if you can do everything properly. But the Constitution itself has addressed the questions of transition until the time when you have a proper president.
You're talking about a caretaker government.
Not a caretaker, not a caretaker. The Constitution has not, the word caretaker does not exist in our Constitution. It doesn't. The only words that exist in our Constitution is president, or in his absence, who should hold office. So our Constitution, in my view, is wholesome. It answers, and it envisages that at no given time should we have a vacancy. Yeah. There will always be someone or there will always be a mechanism through which this process, the governance will continue. Someone will be holding the office or acting in that particular office.
So why,
there's
are people saying that if we go beyond the 60 days, we'll have a constitutional crisis?
No, that's constitutional nonsense. There's nothing like that. But let me say this. Again, I'll keep coming to this point. Willis, I am sure you have read Justice Mativo's decision today.
Yes.
The only thing he didn't say was not just about Ekuru being allowed into the role.
Yes.
Again, I come to this point. It is important. It is incumbent upon us to inform the Kenyan people everything that the court said. For example, the issue that you raised about Rachel Desdeda, that this was an issue, by the way, the court went at length. Justice Mativo went at length to actually show why that decision of the Supreme Court is not binding. He actually discussed it in almost 5 pages or so, actually saying 2 things. The Constitution, the Supreme Court went into an area that over which it had no jurisdiction on interpretation of the Constitution. The basis on which it made it was wrong. That issue was not well thought through, and that it even breached an individual's rights. In a sense, Raila 2013 has no foundation as we speak today. So it cannot now give you rights. Now the problem is that it is important for NASA at this point to hold on to Raila 2013. But the reality is, whether we like it or not, there are many people who may not like it. But there was a decision this morning that actually put Raila 2013 away. So we need to live with that reality and then ask, what is it that we can do in view of the decision by Mativo this morning? 1, that Raila 2013 does not apply. 2, that we cannot have nominations in a fresh election. The 60-day window cannot allow it. Number 3, that yes, the orders given are for Ekuru, but all the other candidates in a fresh election are entitled to stand. What we should be asking is, do we have the technical capacity to have an election in 14 days? Now, one of the things I would hate to do is to sit here and litigate Otimofo and Al Gore. They are not here, their lawyers are not here, IBC is not here. So we cannot throw things, they said they did this, they didn't. It is not useful. It is exciting politically, but as lawyers, it would be unfair for us to do that. I think let us deal with what the law is, what the facts are, and let us leave other suppositions and conspiracy theories to politicians. It excites them. The rest of us, let us deal with issues that we can hold on to with our hands.
Let me just say this. Just one point.
This is very important.
To clarify one point.
Let me say this, Willis. Number 1, the judgment that was rendered today did not just come about. We argued this court on 4th of October 2017. NASA was a party. They were represented. They actually supported our arguments, and those were my arguments in the court, that the Raila 2013 case, the paragraphs that are being relied on are obiter dictum. They supported that.
Yes, now they've changed.
In our submission.
Now they changed.
Because it's not
I'm
convenient.
at a loss to understand why now the change of heart, that we are clinging so much on Raila 2013.
Let me just read
when
this.
we were making the submissions in the High Court, they supported that decision. Because number 1, the issue of paragraphs 289 to 290 something were raised by the Attorney General, who sought directions from the Supreme Court. It was not a pleaded issue, number 1. It was not canvassed by any party. Even the Attorney General himself, who sought the clarification, never submitted on that issue. So you cannot say that the Supreme Court actually interpreted the Article 140 to give the opinion that they gave. And that's what Mativo did in his judgment.
So let me just say this. Let me just say this. I'm a student of law, as I said earlier, and the point is very simple. Can a High Court overrule the decision of a Supreme Court? Let me finish. I'm coming. Allow me to talk. Let me finish. Please, don't shout. Let me finish.
No, it's true.
Can a High Court overturn a decision of a Supreme Court?
All
of them, no. Let me finish, please. Don't shout. Don't shout. Don't shout. Then I'm reading. A High Court can never overrule a Supreme Court, even if the High Court disagrees with it.
But they're saying read Mativo's.
I'm coming. I'm reading for you. I'm reading for you something here. And they've said this is an obiter decision. I'm reading the case of Honorable Lemanken Aramat and Arun Metaitei Lempaka versus Independent Electoral and Boundaries Commission and Isaac Ruto. The Supreme Court of Kenya said this. The emerging lesson is that the decisions of Kenya's Supreme Court, which ought always to be arrived at only after the most conscientious and detailed consideration will stand as the binding reference point in the norms governing the judicial process. Such a position is vital for the maintenance of the certainty, predictability, and jurisprudential standards that sustain the principles of the Constitution and the rights and duties flowing from the legal setup. And then they go further, let me finish, and then they go further to quote the case of the Republic of McLeod, where they say, in my view, the law is that any obiter dicta comments of the Supreme Court should be accorded deference by other courts.
Yeah, you know,
yes.
Such that this, we may not agree, but this is what the Supreme Court of Kenya
forum.
has said.
This is not
It's
the
not the
forum.
forum.
We know
No,
the
no,
forum.
I am
The forum-
simply explaining to you that a Supreme Court, once it has spoken on an issue, we must have legal
I
The
didn't answer
question
the
would,
question
the
yet.
question would be,
Yes.
why didn't they raise that issue in the High Court submissions?
Because
they
it was not
supported.
convenient. That is, and you
What
see,
do you mean
that
it's not
is the
convenient?
point. No, let me say, that is the point I started by saying. The problem where we lawyers are confusing Kenyans is because I sit here today and I make a point about how that case is ratio decidendi, it should not be applied. In fact, the High Court, because at that point that argument is convenient to NASA. Tomorrow when the court makes a decision and it makes it inconvenient, they now say, wait a minute, that decision is binding. You see, that inconsistency is what is giving Kenyans problems. So what we are saying, Will, is there is no problem with you having a position, because in any case it's a cause that would, not me and you, but at least be consistent.
So let me ask you,
Yeah.
is there a problem with the decision of the Supreme Court of Kenya in petition number 5 of 2013?
I will tell you.
Let me just, you asked me that
No,
I should be
I
consistent.
litigated-
Is there a
You litigated
problem?
the case.
No, 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 no.
You-
Number 5, you didn't, no, you didn't litigate.
litigated-
No,
He
I-
did not
I am the
litigate
person who
in number
brought that
5.
case
No, 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 no,
in
no,
the
no.
High Court.
Please,
So
Nani,
I'm better
Wakili.
suited to tell-
Wakili, no, no, Wakili.
Yes.
Let's be clear.
But I also
You
didn't
did not
litigate, so let
litigate.
him
You
answer
did
you.
not litigate petition number 5 of 2013. You are not in court in that matter. Limit
you have
yourself
read the decision.
to the judgment of that
And it was
case. So that
subject
if
to
you
my
can
petition in the High
comment,
Court.
you
So
can
I know
comment
about
on
that case.
you can comment on it. But my question is this: is there a problem with that decision?
The court said there is. That is precisely the point. It is not you. Willis, you can't ask a question and then you don't let me answer. The question is not whether I think there's a problem with Raila 2013. The decision is the court today said that there's a problem with Raila 2013. So you and I may have different views, but that is the law. And what I am saying, it is wrong to our clients, it is wrong to our country when we shift positions depending on what is politically convenient.
And that's exactly what you are doing. In Raila 2013, it is right that the same decision declared Uhuru Kenyatta president. But they're having a problem with that same decision prescribing the withdrawal of a candidate in a fresh election.
No.
For me,
I just
and where I'm
asked.
sitting, let me finish. I have said in the question of consistency, I am consistent in saying this. The decision of the Supreme Court in Raila 2013 was correct in declaring Uhuru Kenyatta president.
Okay.
That decision was also correct in prescribing that a candidate can withdraw. And if that candidate withdraws,
Okay, Willis,
what should sorry,
lower volume, lower volume.
what should ensue?
Yes.
What should ensue upon a withdrawal by a candidate are fresh nominations. So to me, I'm very consistent in my reading of the entire Raila
Okay,
2013.
gentlemen, do you agree?
There are several paragraphs that Willis is not talking about in that judgment. It's not only about one candidate withdrawing. We have a scenario where the courts, and the court was giving hypothetical scenarios, and there are about 5 hypothetical scenarios. One of them is what Willis is talking about. Another one is where we have a voter who is petitioning the Supreme Court for nullification of an election. The Supreme Court gave an hypothetical solution to that situation. It also talked about where we have the election invalidated, none of the candidates withdraws. Then it went ahead to say that all the other candidates who had participated in the previous election are eligible to participate in the forthcoming election. And I wish Willis would be honest enough to say that our submissions before Mativo were in support of Ekuru's application, to the extent that they were saying Raila 2013 was not good law.
That is not true. Please,
That is-
no.
that was the submissions in the High
All right,
Court.
let me
What
just-
was said was
okay.
that we supported their inclusion without attacking the substance of Raila 2013.
Okay, before we take a break, gentlemen, somebody answer this question for me. Will NASA be part of the October 26th election? I just need an answer, yes or no?
Well, I suppose NASA says there will not be. And by the way, you know, it is a constitutional right not to participate in an election. You know, we are not a democracy where we have compulsory voting or candidates can choose not to participate in elections. And sometimes there will be reasonable grounds. And I think that some of the issues that NASA has raised, and I've read the 10, I think there are about 11 reducible minimum.
Yeah.
I've read, I can say that as myself, as a citizen, it is not my business to determine which is not. But I would say about 3 or 4 or 5 of them are actually fairly reasonable and they are good for everybody. But there are others which actually are intended to be an obstacle to an election. Now, they can decide themselves that they will not participate, and that is their constitutional right.
But, Elias, let me ask you this. An election is supposed to be held in all 290 constituencies.
Yes.
Must.
Yes.
And if not?
Let me answer that. Held. What does the word held mean? If IBC organizes and manages election in all the constituencies, then elections are held. If you choose not to participate, that means you're exercising your right not